So this is Bill 21 Day. Ruling came out earlier this afternoon, ruling that, in fact, Bill 21 does not, in fact, violate the Charter of Rights and Freedoms, Quebec's or Canada's, and that the ruling stays in place and that the preemptive use of the notwithstanding clause was okay and applies and can stay there. Julius Grey is a constitutional lawyer. Mr. Grey, thanks so much for your time this afternoon. I'd begin by asking, first of all, your reaction to the ruling today.
Well, I was very disappointed. I think the Court of Appeal missed an opportunity to advance Canadian constitutional human rights law, but I want to stress that the case is far from over. There is the Supreme Court of Canada and the UN Human Rights Committee, which are ahead of us, and I am convinced that this is merely a setback and not a final defeat.
Was there something specific in the ruling that you could look at and go, they've made a big mistake here with respect to how they decided this was okay?
Well, I think certainly on the English cultural rights, they have a narrow interpretation, contrary to that given by Mr. Justice Blanchard in the first instance. I think they're wrong. I think the intention of Section 23 was to permit a different culture to coexist with the majority one. And that different culture has a different view of secularism. Not that it is not secular, but that it has a different interpretation. And especially at a time like today, when Quebec, and not only Quebec, many other jurisdictions, are preoccupied in an unhealthy way, I think, with identity and national identification. It was important to permit the other type of culture to stay. And I think Mr. Justice Blanchard did that. And we shall certainly try to get that reinstated. On the rest, I think the gender discrimination, which the court found did not exist, is there. It's simply by the fact that statistically the people most affected are Muslim women. And in fact, we all know that the reason it was done was the hijab. They are not concerned particularly with kippas or even with turbans. It was the hijab for Muslim women that provoked this law, and I think it's closing one's eyes to reality to say that it's not discriminatory in that way. So there you have a number of things. The notwithstanding clause is a harder nut to crack because there have been a number of Supreme Court cases, notably Ford and Henry G., which have given this very permissive interpretation for governments. I think it's time to revisit it, but I do recognize the difficulty. And of course, the difficulty of this judgment is it's going to make the presentation of Section 96, which was supposed to make of the contestation of the language law, that much harder. And that, too, I would say, will necessarily go to the Supreme Court or to the Human Rights Committee. So there it is all of this. I recognize that the notwithstanding clause issue was harder because of Supreme Court jurisprudence. But I think there were many things that have been done to mitigate the effect of a rather intrusive law.
Why will it make, you just mentioned Bill 96 and the notwithstanding clause, which of course is there as well. Why will it make that harder to fight it?
Well, first of all, it makes it harder because of that, because we could challenge that. There are many things in the 96 challenge that that don't require the notwithstanding clause, the constitutional amendment. The school boards, and we are too, but school boards particularly are fighting it on the basis of Section 23. And this was a setback, this last judgment, on use of English education rights as a barrier to legislation of this sort. There are questions of the legitimacy of the rules involving courts that are not dependent on the notwithstanding clause, and which I think are going to be easy to attack in Bill 96. But I still think that this judgment will be an obstacle, not an insurmountable one, and it's unfortunate. I've been involved in both of those cases for several years now, and you feel disappointed I would, however, I'm comforted by the fact that we have the same problem in the Kirpan case. We lost in the Court of Appeal, and the Supreme Court reinstated a Superior Court judgment that was in our favor.
Well, Mr. Gray, there's still a long or a big hill to climb, as they say. Wish you the best, and thank you so much for your time.
It's a pleasure.
Julius Grey. So there you go. His take. This will go to the Supreme Court of Canada. He's very positive of that. He mentioned the decision basically affecting, women wearing hijabs. There has been a reaction today. I read one earlier in the afternoon, but right now, Idil Issa, who's with the Canadian Council for Muslim Women, is on the line. Thank you so much for your time this afternoon. Please tell us your reaction to the ruling today.
Well, thanks for having me first off. And unfortunately, I was very disappointed with the decision today. I felt that it was disappointing to see an even further rollback in terms of the English Montreal School Board. It's not a good day, I could say.
Did you hear from friends, associates, anybody? Because I remember reading an earlier note today from another organization saying their phone has been ringing off the hook nonstop since this ruling.
Yeah, we have. So I started an informal online network called Femmes Musulmanes contre le Racisme, and we've been chatting informally amongst ourselves in regards to this ruling. So many women in the group are Muslim, and they self-identify as Muslim, and they wear the hijab, and many of them are in the teaching profession. And so this really affects them very personally. And it's been received just in a way that with disappointment. Yeah.
You heard, I don't know if you did hear Julius Grey, the constitutional lawyer, talk about the fact that the battle here is not over, that this will go forward to the Supreme Court of Canada. We also heard earlier, by the way, from Melanie Joly, suggesting that the federal government, would get involved here if and when it got to that level, and something they said before, and that was confirmed later on by the federal justice minister. So are you at least, do you feel better because of that?
Yeah, I mean, I think just the extent to which the rights of Canadians have been infringed for this bill to enshrine secularism in Quebec, I think it just goes way too far. And we're seeing all of these challenges, these court challenges, because it goes too far. So I think I welcome the federal government's participation. It's a bit late, I would say, but I definitely think it warrants it.
Idil, I thank you so much. Appreciate your time.
Thank you.
Idil Issa, Canadian Council for Muslim Women. Anthony Housefather reacting to this today as well. He's on the line right now. Anthony, thank you for making the time.
Thank you, Aaron.
We heard from Melanie Joly. We heard from the Justice Minister as well today. So give me your 2 cents on this. What do you think?
I mean, I think there's two issues where we need to make sure that we intervene at the Supreme Court and we make our position very clear. One of them is on the notwithstanding clause and the fact that the preemptive use of the notwithstanding clause should be unconstitutional. It's not a surprise to me that the Court of Appeal decided the way they did because they were relying on a Supreme Court precedent from the 1980s, and only the Supreme Court is really going to overrule its own precedent. So that is where the federal government standing tall on behalf of Canadians' rights is really important. And the other disappointing factor that I hope we will weigh in on is the reversal on Section 23, where they came up with a very narrow reading of Section 23 and then made the law apply to the English school boards. So these are the two main issues in the judgment. The first was not a surprise to me at all. The second was more of a surprise that they reversed on the Section 23 grounds. But I think in the end result, this is going to get getting appealed to the Supreme Court. And I will make sure to work with the Justice Minister and others to make sure that the federal government is there and that our views are really heard on this.
Just as a final question, with respect to Section 23 that you're referring to, can you just give our listeners an idea of what that constitutes and why that's an issue?
Sure. So Section 23 is English language education rights or French language education rights, depending on what province you're in. It's the minority language education rights provisions of the Charter, and they are not subject to the notwithstanding clause. In the trial court, the original judge had found that the English school boards were exempt because he took a very broad reading of Section 23 and talked about the cultural mosaic that made up the English-speaking community of Quebec and the English school boards and the right to keep their schools reflective of the community And the Court of Appeal basically said, no, minority language education rights are the right of someone to be educated in English in Quebec. It doesn't extend to the point that the trial judge had stated.
All right. And that's the troubling part of this particular ruling today?
Well, I mean, yes, although
Over
to me
and
the
above.
bigger issue is
Yeah.
the notwithstanding clause
Right.
being used preemptively, because that shields the entire law.
Yeah.
And if you take that away, then the whole law will fall.
Okay. Anthony, as always, I thank you. I appreciate you weighing in on this.